Time and again, we've seen the current conservative majority Supreme Court undo decades of precedent to rule in favor of Republican interests on everything from abortion to affirmative action. But now the court has a new opportunity to cater to the far right and directly help Donald Trump in one of his many criminal cases. Yesterday, the justices agreed to hear a case that will consider whether the government can charge January 6th rioters with a statute that makes it a crime to obstruct an official proceeding, which could not only upend the prosecutions of hundreds of insurrectionists who've already been charged or sentenced, but could also potentially impact or delay special counsel Jack Smith's election interference case, as obstruction is one of the 4 counts brought against Trump. A delay is exactly what Smith was trying to avoid when just days ago he asked the Supreme Court to fast-track a review of Trump's claim that he is immune from prosecutions of any kind, even for trying to forcibly stay in office, because it happened while he was president. And while it may seem like there would be a pretty obvious answer there, the people who could be deciding this are 3 Trump-appointed justices, along with Clarence Thomas and Samuel Alito. Joining me now is Melissa Murray, law professor at New York University, former clerk to Judge Sonia Sotomayor, and MSNBC legal analyst. Melissa, how on earth could a case even make it to the Supreme Court that says that the government can't charge people who did insurrection, with interfering with the processes of Congress?
Well, Joy, the case is called Fisher versus United States, and this January 6th rioter was charged under the statute that was actually passed in the wake of the Enron scandal. So one of the arguments that was made was that the statute was never intended to apply to a situation where someone was obstructing a congressional proceeding, but rather was meant to deal with circumstances where individuals were doing things like evidence tampering in furtherance of the obstruction of official proceedings. And so these don't necessarily match up. Mr. Fisher is also arguing that he was never in the Capitol for a long time, and for that reason had no intent to actually obstruct the congressional proceeding. So it's really a question of statutory interpretation and whether the scope and substance of this statutory provision was meant to apply to this kind of conduct, the rioting at the Capitol.
And how could that possibly then apply to Trump? Because Trump, at least if you read Jack Smith's filing, was directly trying to interfere with the processes of Congress, since the process in question was certifying the election of somebody other than him.
That's exactly right. I think, though, if this court is inclined to rule for Mr. Fisher that this statute does not apply to him, that it was not intended to apply to him, then it raises questions about whether it should be applied to Mr. Trump. And again, it is one of the 4 charges in that January 6th election interference indictment that Jack Smith has filed. And this really puts the Supreme Court and its conservative supermajority on their heels a bit, because this is a court that has said that you've got to look at the 4 corners of the statute, the words of the statute, the text of the statute. If you look at the text of the statute, I think a very natural reading of it is that it could apply in circumstances where individuals were trying to obstruct any official proceeding, whether it was something with regard to the valuation of a company or a congressional proceeding like this one. It is only if you look to the purpose of the statute and look at its origins in the Enron scandal that maybe things get a little shakier. But this is a court of committed textualists, so we'll see just how committed they are.
Or it's a court of Aileen Cannons, who are committed to do whatever they want, and whatever suits them in the moment, and especially if it helps maybe their guy, Donald Trump. Let me read you, because I think Jack Smith's filing actually was pretty brilliant. His strategy has been really brilliant to try to cut Donald Trump off from this delay strategy. This is what Public Notice wrote about it. Trump's lawyers insist that the Constitution's Take Care clause made Trump an all-purpose policeman obliged to interfere with the certification of President Biden's electoral victory. This is a particularly odd position because the 12th Amendment to the Constitution lays out specific roles for Congress and the vice president in the electoral certification, but not for the president. So talk about this just for a moment, because it is slightly unusual for the Supreme Court to skip the D.C. circuit and to just jump before them. But it's not completely unusual, right? And is this a solid argument on the part of Trump's lawyers that somehow interfering with the election is part of his job?
Right. So we're pivoting from the Fisher case, which is about the January 6th charges, and now turning to Trump's efforts to delay this trial altogether by arguing that he is immune from prosecution as a former president. What Jack Smith has done here is basically said, we can't wait for the Intermediate Appellate Court to make a ruling here. That would take too long. This country needs to know whether one of its candidates for president is a convicted felon or not. And so it is sought certiorari without judgment, before judgment in this case, case. And it's asked the Supreme Court to not only do that, to take this case, but to do so with incredible expedition. And the question that the court has to address is whether the scope of presidential immunity, which has never been applied in the context of a criminal case, because we have never had a former president or a sitting president be indicted on criminal charges, but whether or not the scope of presidential immunity goes so far as to insulate a president from criminal charges. And Donald Trump is arguing that his discouragement of the counting of the votes or the certification of the votes in Congress, that was merely part of his job as president and therefore within the scope, within that outer perimeter of his duties, and therefore renders him immune. Jack Smith is arguing that he wasn't even supposed to be there. That is a job for the vice president.
Right.
This is not part of the president's official duties. He has no immunity here.
Yeah. Really quickly, based on Dobbs, should we just expect that the same 5 who overturned abortion rights will rule against mifepristone? Should we just brace ourselves for that?
I think this is going to present a real challenge for this court because Dobbs, basically the court said that this is an issue that should be decided by the states, by the people, and yet we have a decision, if the court rules in favor of the Fifth Circuit, would make it very difficult for the abortion pill to be accessed around the country, even in those states where there are more liberal abortion policies. I also think it's important to note that this case is like a Venn diagram where it pits the conservatives' antipathy for abortion with their antipathy for the administrative state and gives them an opportunity to really stick it to the FDA and administrative agencies. So who knows if they'll be able to resist.
Yeah, and also Samuel Alito is, he thinks he's doing God's work, his version of God's work, and they're going to do what they want. Melissa Murray, thank you very much.